Hearing in the appeal, the Lord Advocate representing the Taiwanese judicial authorities and deans.
My Lords, I appeal this appeal with Mr Dixon and all defendants Mr Bowden and Mr Brown for the following. The essential issue in this case is about the approach to be taken to assurances given by a requesting territory in relation to the management of risks to a prisoner's safety when in custody. I appear pursuant to my statutory duty under the Extradition Act to act on behalf of requesting territories, and I also have a general interest in the correct approach being taken to issues of this sort. My short submission will be that, as in so many matters of this sort, the beginning of wisdom is to be found in an analysis provided by Lord Brown of Eton under Heywood. In this case, in the case of Bagdanavicius, and it will be my submission that because the risk of ill treatment with which we are concerned is a risk of ill treatment at the hands of non-state actors, the critical question is whether or not the requesting territory will provide reasonable protection against the risk of ill treatment. It will be my submission that it is not enough to conclude that there is a real risk of ill treatment, nor indeed is it enough to conclude that, assuming implementation of assurances given, there remains a real risk of ill treatment. The key question in a case of this sort is whether or not reasonable protection against the risk is provided by the authorities in the requesting territory.
Might that be the other side of the coin to whether there's a real risk of ill treatment? Might that be the other side of the coin to the question whether there's a real risk of ill treatment? I mean, one would have thought that in the context of a prison, reasonable protection means guarding prisoners against a real risk of ill treatment.
Indeed, my lord. The point that I will wish to make to the court is that in that context, and recognising that prison authorities have responsibilities to keep prisoners safe, recognising, though, that that is a duty of or an obligation of reasonable protection, that the right focus is to focus on the assurances or other bases upon which the court can be satisfied that reasonable protection will be provided. And that the...
Presumably is that you submit that there is no guarantee of effectiveness if the steps which the authority proposes to take are reasonable.
Indeed. Indeed. And it'll be my submission that if that is correct, then the majority of the High Court have failed to address the correct test in law. And it'll be my submission that, in light of the assurances given, the requesting territory does offer to provide, and on the assumption those assurances are satisfied, will provide reasonable measures of...
I mean, I suppose if the position was such that, for example, this was someone who it was known that all other prisoners would wish to kill, even if it meant them serving the rest of their life in prison, or possibly even, I don't know, death penalties still exist in Taiwan? It probably does.
It does, but assurances have been given in that respect. So possibly even exposing themselves to that. If it really were the case that
all other prisoners were going to be out to get someone, willy-nilly, whatever the consequences for themselves, then it might be that it was simply impossible to provide protection.
Well, in a case such as that, the protection that might be provided would be to keep the individual in accommodation separated from other prisoners.
Yes, I see.
We had a case like that about a year ago, didn't we?
We did.
Shahid.
Indeed, my lord.
And then the question would be, I suppose, whether that was tolerable itself. But assuming it was, then
Such questions would arise.
Yes.
But it's perhaps anticipating the submission. Our way of protecting a prisoner against risks to his safety is to keep the prisoner separate from other prisoners. We recognise that in our own system. There then comes a question about duration and so on and so forth. The Osselan case is a good example of a Strasbourg case where the individual was kept in isolation from other prisoners over a period of many years.
Shahid itself was about 5 years.
Indeed, my lord. Indeed.
Lord Advocate, you found strongly in your written submission and also this morning on Bogdanovicius, was that before the Inner House?
It was, my lord.
It was, because I don't think it featured in their judgment.
I'd have to check.
But it was.
I'd have to check, but it was certainly before them. It was certainly before them, my
Thank
lord. Can I say there is perhaps a general... it's maybe worth making this general point now rather than later, which is that one mustn't... There are clearly challenges for a court in this jurisdiction having to assess prospectively the level of risk in a foreign jurisdiction. That presents a number of challenges. In my submission, it would... what I say is the correct analysis in law, which is to focus, assuming that one crosses a threshold of risk or threat, to focus on the question of the reasonable measures of protection, fits well with an appropriate approach to the overall working of the extradition system. It means that it would mean that in a case such as this, while no doubt there would require to be material about the nature and level of risk to which a prisoner might be subjected, the court could focus on the question of whether the penal arrangements in the requesting territory do or do not provide reasonable protection.
I mean, one shouldn't too lightly engage in fanciful speculation or speculation as to what are in reality remote possibilities.
Well,
one can accept that well enough.
I certainly I wouldn't wish to suggest that any court would engage in fanciful speculation. I think the point I'm making, my lord, is that in any case where the court is asking itself whether there's a real risk of treatment in breach of Article 3, the court is having to engage in an exercise of prediction.
Yes.
And the Strasbourg court itself, in the case of Ahmad, has recognised that can be a difficult exercise. If one's thinking about the level of risk to a particular prisoner in the context of a foreign penal regime, it may be quite possible to identify risk, but for a court in this jurisdiction to engage in an elaborate fact-finding exercise to set up a finely calibrated analysis of the level of risk is an exercise which is not without its challenges. And the short way through, if one recognises that a real, not fanciful risk exists, is to focus on the question of reasonable protection. And
well, you'll have to, I'm sure you'll get into it at some point, you'll have to face the fact that on a very factual issue, on one view, in a House by a majority has come to a particular
Yes.
conclusion, and I'm sure you will deal with points where you say it has departed from an approach based on a reasonable level of protection and really engaged in some different exercise, some more extreme.
Well, I'm quite content, because I'm particularly interested in the right approach being taken here. I'm quite content to take that this court should proceed on the basis that the High Court was correct to identify a real risk of ill treatment. I have to recognise that there was evidence of violence of violent incidents in the prison in the past. I have to recognise that there was evidence of the respondent having a level of notoriety. I have to recognise that.
Yes, so the assurances were necessary. You're saying, is that right?
The assurances, in the context of this appeal, I have to recognise the factual findings that the High Court has made, and because I'm interested in focusing this sharp issue, I am content to accept that that the High Court, the majority, were entitled to find that there was a real risk of ill treatment, in the sense that there was evidence of previous instances of violence, evidence of an individual who has a level of notoriety, and evidence of understaffing.
Well, what I don't follow at the moment is, are you saying that you recognise that the factual findings made by the High Court mean that there was a real risk of ill treatment, despite the assurances and all the measures of protection which the assurances said would be put into effect?
As we'll see when we look at Bogdanovich, I can accept that and still say that they have missed the point in terms of not addressing the critical question.
Yes, you say the prisoners, you're willing to accept that the prisoners could pose a risk to
Yes.
To Mr. Dean. But you say what the court has failed to do is apply the Bogdanovich's test.
Indeed.
And therefore it's open to us on the findings of fact of the inner house to reach our own view applying Bogdanovich's.
Indeed. And I will be inviting the court to focus on recognising that there are those primary findings for which there is evidence to take the view that the assurances given provide reasonable protection.
Yes.
I don't know if you're going to deal with this, Lord Advocate, but if one's thinking about the right approach to adopt, one aspect of this case that's very striking is how long it's taken.
Indeed.
I don't know if that's related to the approach adopted, but I'm just mentioning it.
Indeed, my lord. That's not lost on me. Perhaps I should make a couple of preliminary observations and then come to the main issue. First, as a matter of terminology, I'm going to describe Taiwan as the requesting territory. I do that because Taiwan is not recognized by the United Kingdom as a state. The second point is just to set the legal context that we're dealing here with a devolution issue appeal. The court below concluded extradition of the respondent would be incompatible with Article 3. That raises a devolution issue, namely whether an apprehended act of the Scottish ministers in extraditing the respondent would be compatible with these convention rights. And in relation to the competency of an appeal of this sort generally, as a generality, I point to the case of BH, which the court has at tab 4, and it's not necessary, I think, to turn these up unless the court wishes to, at paragraphs 24 to 34, and also Capri at tab 16, paragraphs 14 to 23. The question of whether or not a devolution issue arises or does not arise is a matter of substance, not form. And that's the case of MacDonald particularly Lord Hope at 11 to 19, Lord Roger at 48 to 49. And I make a couple of observations in response to, in anticipation of a competency point that my learned friend may make. First of all, that this devolution issue is, of course, one that he raised. It was he who contended it would not be compatible with Article 3 to extradite him.
I thought it was a point that he raised on the permission to appeal, the permission to appeal stage, wasn't it?
Indeed.
Well, I mean, there's a question as to how far it can be re-argued at this stage, since we've given permission to appeal.
Indeed, my lord. There is one point
We certainly considered it.
raised more recently, which is a point about the position of the Advocate General for Scotland quite properly. I may say the Advocate General's office has been aware of this case from the outset, and specifically about this appeal from shortly after I think permission was granted. It is correct that the grant of permission was not formally intimated to him in accordance with this court's practice direction until after my learned friend identified the point. That has now been done. It was done on the 24th of February, and I understand that the Advocate General's office has intimated to the court that he does not wish to intervene. So in my submission, if the point's raised, there's a short answer to it, which is the Advocate General is well aware of the case and has chosen not to intervene.
Can you remind me, whose obligation is it to intimate to the Advocate General? Was it yours?
I should have intimated. Well, I'm required by the practice direction, having been granted permission to appeal, as I understand it, to intimate.
Yes.
There is no time limit, I don't think, in the practice direction. It's regrettable it wasn't done immediately. I may say the Advocate General's office was well aware of the case and had been sent the papers in the case. But as a matter of formal intimation, that wasn't done until 24th of February, and that was a regrettable oversight.
Under the Scotland Act, is it only at this appellate stage that you need to give notice?
No, the Advocate General is entitled to be involved at all stages.
So this is a defect which existed below, if it existed at all.
The Advocate General had intimated to him the respondent's devolution minutes at first instance.
I see.
And has been therefore had.
He did have notice below,
had
but
notice
not.
in the Sheriff Court.
Yes, I see.
The respondent failed in the Article 3 argument before the Sheriff, appealed that, argued it in the appeal court. If there is a problem of non-intimation at appeal court stage, then in my submission it did respond.
I was going to say, yes, it's the same.
Indeed,
right.
Indeed.
Yeah.
There were further devolution, but there have been a lot of devolution events in this case. I think there have been ones raising Article 3 issues intimated both in the Sheriff Court and in the Inner House.
Indeed. So with that preamble, perhaps I can just focus on what I say is the main issue in this case. The Court's well aware that in response to concerns about the general conditions in Cape High Prison, the requesting territory has given a number of assurances. In particular, the assurance that the respondent will be held in particular cellular accommodation. And secondly, and of particularly germane to this case, this appeal, as regards the approach which will be taken to protecting the safety of the respondent. No issue arises as to the former assurance or as to the conditions of cellular accommodation to which that assurance refers. The assurance in relation to the approach that will be taken to protecting the respondent's safety is the assurance of 25th February 2014, which is at MS 631, but which is quoted in my case at MS 62 to 64. And I invite the Court, I don't know if it's necessary for me to do so now, but I invite the Court to attend closely to the terms of that assurance. And in my submission, it contains within it, first of all, commitments in relation to the assessment of risk. And one can see that particularly at the bottom of MS 62 on to MS 63. Commitments to respond to concerns which the respondent may raise about risk to him. Commitments as regards the choice of cellmate. One can see that at MS 62.5. And commitments to act if a risk is identified. And that's also at MS 63. In particular, at MS 63 under a paragraph described as 2A, where the question is, if Zane Dean's safety is in danger, what are the procedures in place and what actions will the prison officials take? First of all, there's a description of the relevant prison legislation, but we're told at the end of that paragraph, thus, should there be any threat to Zane Dean's safety, prison authorities would separate him from group activities, restrict his interaction with other inmates, and change his daily routine if necessary. In addition, any food or other items delivered to him would be thoroughly inspected to ensure that any dangerous items do not get through. And the writer of the assurance goes on to say that the evaluation of prisoners coming in contact with Zane Dean would be carefully scrutinised and surveillance conducted if need be. If at any point a correction official suspected danger of any sort from another inmate, he would report to a supervisor who would intervene, immediately transferring the suspect to a different cell and delivering the evidence to the relevant authorities for investigation. So one has, and I do invite the court to read the whole assurance carefully, one has a series of commitments in relation to the responding to concerns about risk, to assessing risk, and to taking action if risk is identified. And this, of course, against the background now of a prisoner who, when in his cell, will be in a special cell separate from the main prison with one other cellmate who will be a foreign prisoner. And one can see an assurance at MS 62.5 about the way that cellmates will be chosen for the respondent. So my submission is that the measures described in this assurance, if implemented, are such as to provide reasonable protection for a prisoner such as the respondent. Now, the key point from a legal perspective in terms of the analysis here is that this is not a case where the apprehended risk to the respondent is of ill treatment at the hands of agents of the state. The real risk which the court below has concluded exists is a risk at the hands of other prisoners. And that takes one immediately to Bagdanavicius, which the court will find at tab 21, MS 1997. It's the first volume of authorities, tab 21, MS 1997. The opinions start at MS 2001, and the court will see that all of their lordships and her ladyship sitting in that case agreed with Lord Brown I commend to the court the entirety of Lord Brown's relatively short speech. But if I might draw the court's attention to certain salient points in the case. After some preamble about the distinction between domestic cases and expulsion or extradition cases, at paragraph 8, His Lordship observes, ordinarily in these foreign cases, the risk which the individual runs of being subjected following expulsion to the prescribed form of treatment emanates from intentionally inflicted acts on the part of the public authorities in the receiving country. As, however, was first stated by the European Court of Human Rights in HLR, owing to the absolute character of the rights guaranteed, the Court does not rule out the possibility that Article 3 may also apply where the danger emanates from persons or groups of persons who are not public officials. However, it must be shown that the risk is real and that the authorities of the receiving state are not able to obviate the risk by providing appropriate protection. And then he refers to subsequent briefly to subsequent authorities, and at 11 he says, HLR and D bring me at last to the critical issue arising for determination on the present appeal, another case where the risk arising is that of harm threatened by non-state agents. The issue may be formulated as follows. To avoid expulsion on Article 3 grounds, must the applicant establish only that in the receiving country he would be at real risk of suffering serious harm from non-state agents, or must he go further and establish, too, that the receiving country does not provide for those within its territory a reasonable level of protection against such harm? Mr. Nicol, for the appellants, a Lithuanian couple with a young child, submits they need establish only a real risk of harm on return. For the Secretary of State, Ms. Cass-Frisk's principal submission is the appellants must also establish that the receiving country would fail to discharge the positive obligation inherent in Article 3 to provide a reasonable level of protection. It is, of course, implicit in the formulation of the issue in this way that a real risk of injury may remain despite the state's provision of a reasonable level of protection against it, and such indeed I understand to be the agreed position on the facts of this very case. The recognition of the point that I think my Lord Sumption made, that it is not an absolute level of protection, it's a reasonable level of protection. A real risk may remain.
Is that consistent with what the court said, at any rate, in HLR versus France in paragraph 8? One looks at the second sentence. However, it must be shown that the risk is real and that the authorities of the receiving state are not able to obviate the risk by providing appropriate protection.
Indeed. My Lord, I'll come later in the judgment to a paragraph where His Lordship addresses that directly.
Okay.
Under reference to, he credits Lord Hope with identifying that the key verb is the French verb obvier.
Right.
He then goes on at paragraph 13 to record the submission made by Miss Cass-Frisk. Formulating the issue in a particular way, but goes on himself to say, for my part, however, I prefer to decide the appeal by reference to the issue earlier formulated. In other words, are there two stages that must be met? On this basis, of course, the detailed facts of the case are of no particular importance, and it's quite sufficient to summarise them. And he then goes on to do that. And then at paragraph 17, he refers to the Sering principle. And then at 18, that statement of the principle requires on its face that the person in question, to avoid being expelled, must show substantial grounds for believing that he would face a real risk of being subject to treatment contrary to Article 3, the prescribed forms of treatment, as the court put it in D, in the receiving country. Central to Mr. Nichols' whole argument, however, is that in cases where violence in the receiving country is threatened by non-state agents, expulsion is barred irrespective of whether or not the receiving state itself would thereby in breach of Article 3, or if not itself a contracting state in what has been called a notional breach of Article 3. Of course, the context there, my lords, is that domestically, the obligation of the state is one of reasonable protection. All that Mr. Nichols says need be established is that the person concerned is at substantial risk of suffering harm to a degree sufficient to engage Article 3. In other words, the member state expelling the person can be in breach of Article 3 because of the risk of injury he runs on return, even though, were that risk to eventuate, the receiving country itself would not be. At first blush, says His Lordship, this is a surprising contention. And then His Lordship sets out the argument advanced by Mr. Nicholl, paragraph 20, paragraphs from Sering. And at 21, he points out that Mr. Nicholl focused on the third sentence of that passage, which he submitted in which he submitted the court was making it plain there's no need for the person concerned to establish the feared risk is of harm, such as would place the receiving country itself in actual or notional breach of Article 3. Yeah. And then Lord Brown goes on to say, in my judgment, the argument is a hopeless one.
Yes, I suppose, for example, if a prisoner in the position of Mr. Shahid was at real risk of being attacked in prison, it wouldn't be a breach of Article 3 for him to be imprisoned, provided prison authorities are taking reasonable steps to protect him.
Indeed, indeed. And I can show the court in a moment the case of Edwards against the United Kingdom, where a prisoner in a UK prison was killed, and the Strasbourg court discusses the obligation of the member state. And the background, of course, to Edwards is Osman. Then His Lordship goes on to say, all the third sentence of para 91, that's the sentence in Sering, is saying the court need not and should not reach any decision as to whether the receiving country, a sovereign state which in any event is not represented before the court, actually is or notionally would be in breach of Article 3. All that need to be decided is whether there are substantial grounds for believing there would be a real risk of this. To that end, of course, it is necessary, as the second sentence points out, to make an assessment of conditions in the receiving country, the requesting country in Sering. This is necessary so the court may determine whether or not there is a real risk that the person concerned will suffer harm involving an actual or notional violation of Article 3 in the receiving country.
Yeah. So the issue isn't whether there's a real risk of harm, it's whether there's a real risk of a violation of Article 3.
Indeed. That's precisely the point that His Lordship is making. And he goes on to say, it's noteworthy that the risk referred to in the first sentence of para 91 is of being subjected to torture or to inhuman or degrading treatment or punishment. Prescribed ill treatment as that is conveniently summarised in the fourth sentence. The later formulation speaks of a real risk of being subjected to treatment contrary to Article 3. All these expressions in terms refer to harm which, if it eventuates, would involve a violation, actual or notional, of Article 3. The position surely is plain. There is no warrant whatever for reading Sering or any of the other cases at barring expulsion where the real risk is not of prescribed ill treatment, but is merely of harm, however serious. And that's the point that my Lord has just made to me. Yeah. And then he goes on to say, the plain fact is that the argument throughout has been bedevilled by a failure to grasp the distinction in non-state agent cases between, on the one hand, the risk of serious harm, and on the other hand, the risk of treatment contrary to Article 3. In cases where the risk emanates from intentionally inflicted acts of the public authority in the receiving country, one can use those terms interchangeably. The intentionally inflicted acts would without more constitute the prescribed treatment. Where, however, the risk emanates from non-state bodies, that is not so. Any harm inflicted by non-state agents will not constitute Article 3 ill treatment unless, in addition, the state has failed to provide reasonable protection.
That's a critical sentence for your
Absolute
submission.
critical sentence, my lord. If someone is beaten up and seriously injured by a criminal gang, the member state will not be in breach of Article 3 unless it has failed in its positive duty to provide reasonable protection against such criminal acts. This provides the answer to Mr Nichols' reliance on the UK's obligation under Article 3 being a negative obligation, thus absolute. The argument begs the vital question as to what particular risk engages the obligation. Is it the risk merely of harm, or is it the risk of proscribed treatment? In my judgment, it is the latter. The very identification of the issue for determination by the House in the agreed statement of facts and issues illustrates the confusion. If on removal to another country there's a real risk that the person would suffer torture or inhuman or degrading treatment or punishment from non-state agents, will removal violate Article 3, or must the person concerned also show there is in that country an insufficiency of state protection? And then he goes on to say, non-state agents do not subject people to torture or the other prescribed forms of ill treatment, however violently they treat them. What, however, would transform such violent treatment into Article 3 ill treatment would be the state's failure to provide reasonable protection against it. And then he asks whether there's anything in Strasbourg jurisprudence suggesting the contrary, and concludes that there isn't. And then at 27, Mr Nichols seeks to argue that these two conclusions were merely opposite sides of the same coin, i.e. that by definition, if there was no real risk, there was no adequate protection, and vice versa. He stresses in this regard the word obviate in paragraph 40. Again, however, I find the argument impossible. As Lord Justice Sedley pointed out in Macpherson, the Court's apparent requirement that protection is sufficient to obviate the risk cannot be right. What the state is expected to do is to take reasonable measures to make the necessary protection available. The key to understanding the meaning of the word obviate in paragraph 40 of HLR was provided by my noble and learned friend Lord Hope of Craighead, who pointed to the Collins-Robert 4th edition dictionary translation of the French verb obvier as to take precautions against. I think that answers my Lord Mancy's anxiety about the use of the word obviate.
According to Google Translate, that's a secondary meaning. But
Right. I have to confess, I haven't pursued the matter, and my Lord Sumption may well...
at least if I understand the bar is about 3 times as long for the meaning obviate, but I shall put that aside and ignore it.
I'm content to found on
You've got it,
the Lord Brown's adoption of Lord Hope's suggestion and the Court's agreement with that.
Yeah, I mean, whatever the French says, there's a real point to be decided, and it seems to have been decided in this case.
That's really my short point, my Lord. He goes on to say, nothing in the Court's reasoning suggests that it regard its conclusion on the issue of appropriate protection as affected, let alone determined, by its already stated conclusion on risk. To my mind, it is clear the applicant had to succeed on 2 independent points to establish his Article 3 claim, and in fact he succeeded on neither. And of course, the context for Lord Brown's analysis, which in my submission shouldn't be lost sight of, is that in the domestic application of the Convention, the positive obligation of the state is not one of absolute protection, but of reasonable protection. And the Court has, in the bundle at tab 36, the case of Edwards that I mentioned a moment ago. It's an Article 2 case. It's at MS 2390, and the Court at 2409 to 2410 talks about the positive duty on the state in relation to the prevention and protection against injury. In the Edwards case, death. if I could invite the court to look briefly at 2409, MS 2409 at paragraph 54, recognising this
2409 in
2409, recognising it's an Article 2 case, not an Article 3 case. But, 54, the general position in relation to the positive obligation of the state is set out, including in the last sentence the duty in appropriate circumstances to a positive obligation on the authorities to take preventive operational measures to protect an individual whose life is at risk from the criminal acts of another individual. And then at 55, under reference to the unpredictability of human conduct, the operational choices that must be made, the scope of the positive obligation must be interpreted in a way which does not impose an impossible or disproportionate burden on the authorities. Not every claimed risk to life, therefore, can entail for the authorities a convention requirement to take operational measures to prevent that risk from materialising. For a positive obligation to arise, it must be established the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual from the criminal acts of a third party, and they failed to take measures within the scope of their powers which judged reasonably might have been expected to avoid that risk. In the context of prisoners, the court has had previous occasion to emphasise that persons in custody are in a vulnerable position and the authorities are under a duty to protect them, incumbent on the state to account for injuries suffered in custody, and so on. And then at 57, looking at the particular circumstances, the court asks first whether the authorities knew or ought to have known of the existence of a real and immediate risk to Christopher Edwards' life. Secondly, whether they failed to take measures within the scope of their powers, which judged reasonably might be expected to avoid the risk. I refer to that, my lords, simply to make the point that we're concerned here with reasonable measures, measures within the scope of the prison authorities' powers, which might, judged reasonably, might have been expected to avoid risk.
And if that's the standard that Article 3 requires of domestic prisons, then in the context of extradition, it can't require a higher standard of a foreign prison.
That's exactly the point, my lord. And it's the underpinning for Lord Brown's analysis in Baghdad Avicius. Can I say, my lords, that the Edwards case focuses on the existence of a real and immediate risk to an identified individual? I certainly don't go so far as to say that that is the only circumstance in which issues of this sort would arise. If one, for example, were envisaging extradition to a prison where serious violence was known to be endemic, then the mere fact that one could not individualize that risk, in my submission, wouldn't be an answer to the need to address the question of whether reasonable protection is being provided. There's an illustration, I refer to it no more than as an illustration in the bundle of authorities, and I don't think the court needs to turn to it, the case of South Africa against Dawani at tab 30, MS 2202, where the risk was of sexual violence in a South African prison, accepted that there was a real risk, and the risk was addressed by a clear undertaking to hold the prisoner in a single cell. And as it happens, in light of the various undertakings, Sir John Thomas, in that case, was became sure on the facts that there would be no breach of Article 2 or Article 3. But the point of referring to that by way of an illustration is it's a case where there was a recognised general issue of sexual violence addressed by an undertaking to keep the prisoner in a particular cell.
Pending trial.
That was, yes.
It's extradition, isn't it?
Right.
Yes, that was on
Yes.
remand pending trial. For what it is worth, there have been a number of cases in the lower courts where it has been assumed that the Baghdad-Vikius approach applies where the alleged risk is a risk that arises within the prison system of the requested territory. And again, it may be enough simply to give my Lord's references to the cases in the bundle. There's the case of McLean at tab 17, MS 1930.
MS 1?
1930.
Yeah, thank you.
The case of G at tab 10, MS 1857. The case of Shaluki, tab 25, MS 2092. And the case of Stopira, tab 31, MS 2222, particularly at paragraph 76 and following. In the present case, there are two aspects of prison conditions which are at issue. It's perhaps worth distinguishing them. The first was whether the physical conditions of detention were compatible with Article 3, applying the well-known jurisprudence about physical conditions of detention. And that issue has been dealt with by the undertaking to hold the respondent in particular cellular accommodation, which does not exhibit the physical conditions which might otherwise involve treatment incompatible with Article 3.
There's no issue between the parties as to
No issue
that.
between the parties on that. The point I'm making here, my Lord, is that one needs to separate out that
Right.
general issue of prison conditions and the particular issue of threats
Yes.
and the risk of violence at the hands of other prisoners. And in relation to that risk, following Lord Brown's analysis, the approach is to ask, first of all, is there a real risk? But secondly, will the requesting territory provide reasonable protection? And here, and I suppose the question of what's required of the requesting territory is, of course, affected by the fact that the respondent will be detained in prison. But the point of principle that that's the correct analysis in my submission is not affected by that circumstance. And as I observed in my opening observations, in my submission, it's important for the proper working of the extradition system in a case such as this, that the focus is on whether or not reasonable protection will be provided. That should allow authorities in this country to address issues such as this by seeking information about the penal regime and seeking, if necessary, specific assurances on the basis that if that information provides reasonable protection, then it may be, depending on the circumstances, not necessary to engage in an elaborate exercise of prediction and calibration of the precise level of risk. An exercise which, for the reasons I outlined at the outset, is one which is inherently challenging. Now, if I'm right in that analysis, then in my submission it is plain that the majority of the court below went wrong. The error can be seen at paragraph 45 of Lady Peyton's opinion, MS 140, where she says the only live question for this court is whether the undertakings given and special arrangement proposed by the Taiwanese authorities, assuming they're fulfilled to the letter, would have the result the appellant could serve his sentence in Kei prison without there being a real risk of treatment of him incompatible with Article 3. And similarly at paragraph 50 at MS 142, where she expressed herself not satisfied that the exceptional arrangements described would remove the real risk of treatment of the appellant incompatible with Article 3, and similarly at paragraph 58, MS 147. 58 at MS 147.
Yes, yes.
And the short point is this, that if, on applying the analysis of Lord Brown and Bagdon and Issues, the court's conclusion that on the assumption the assurances will be fulfilled, there remains a real risk of harm, is not determinative of the issue. The true question is whether or not the requesting territory will provide a reasonable level of protection. And that's not a question that the court has addressed. And I say that on the assumption made by the majority of the court below the assurances will be fulfilled, the requesting territory does offer to provide reasonable protection. It is undertaken to detain the respondent in a cell which is separate from the main prison with one other prisoner who will also be a foreign prisoner, and applying the assurance which I mentioned at MS 62, care will be taken in his selection. And insofar as the respondent continues to mix with other prisoners and there is a continuing risk of the sort that the court below apprehended, the requesting territory is described specifically in the assurances which have been given, the steps that it will take in order to seek to protect him from violence. They include commitments to assess risk, to respond to issues raised by the respondent, and to take action to respond to risk. And in my submission, in light of the assurances given, the requesting territory offers reasonable protection, and it accordingly would not be incompatible with Article 3 to extradite the respondent. As it happens, in this case, the evidence is that if the respondent is not content that he's being adequately protected, the prison authorities in the requesting territory would permit him to choose to remain in his cell. Perhaps for obvious reasons, I do invite the court to conclude that the assurances on their own provide reasonable protection. But the very fact that the prison authorities would allow the respondent to choose to remain in his cell, even if they don't consider that a necessary measure, reinforces the proposition that the requesting territory offers to provide reasonable protection to him. Now, perhaps I can put the matter this way. If the requesting state prison authorities were to decide in implement of the assurances given that the respondent should be segregated from other prisoners and to keep him in the cell provided for him, that would not involve a breach of Article 3. And I referred the court to Osalan, which is at tab 40. The requesting territory can't be in a worse position if, in addition to the assurances that it will itself take steps to segregate the respondent, if the prison authorities conclude that this is necessary to protect him, they will allow him to choose to keep himself segregated.
Can you just help me? How far was the matter argued in the way that you're putting it below? And although I'm not taking a technical point, how far is it actually covered by your notice of appeal?
I think
You've just challenged the inner house.
Absolutely, my lord, and I entirely accept. Can I accept the case, if I understand it correctly, and Mr. Dixon will correct me if I'm wrong. The case issue was joined in the court below on the issue of real risk, and I accept that. And
similarly in the notice of appeal.
And I accept to that extent that the way that I am focusing the argument before this court is a reflection of my own reflection on the case in preparation for the appeal, and on the need to make sure that the right approach is taken to cases of this sort.
Yes, I mean, it's not a case of an additional focus, it's a complete switch of focus, because you're not actually pursuing the points that were argued in the notice of appeal or below.
I'm taking them all in a sense as
read.
In a sense, I'm prepared to take the case, at its highest against me, and to say let that be so. Even so, the correct legal analysis is a different one. Now, can I say, my lord, that I'm here with the statutory function I mentioned at the outset, but I am concerned that whatever the outcome of this particular case, that the right legal analysis comes to be applied to cases of this sort. And if that's a focus that has impressed itself upon me in preparation for the appeal, then so be it. So be it.
No, well, you've been very open about it, as I'd expect.
So, in what connection was Bagdonovicius referred to below?
Sorry?
You told us that Bagdonovicius was relied on.
It was certainly referred to below.
I was surprised not to see it in either the majority or the minority judgment.
Yes. Yeah, I am being shown by Mr. Dixon the note of argument for the Lord Advocate for the appeal, and there is certainly a paragraph in that which reads, where it is claimed the acts of non-state agents create the real risk of a breach of Article 3, it is also necessary the requested person establish, 1, the nature of the serious harm, and B, the requesting territory is unable to provide a reasonable level of protection against such serious harm.
Yes, which is what you say in paragraph 11 of your written case. And
Bagdonovicius is firmly is referred to. So, in fairness to Mr. Dixon, who presented the case below, that was squarely put in the note of argument.
This is a document which was actually put below, was it, to the court?
Yes, it's a note of argument that was put before the court.
It might be useful to have it.
I think, as I say, Mr. Dixon will correct me if I'm wrong. In the context of the hearing of evidence and submissions, I think it were right to say issue was being joined on the real risk question.
When you say issue was being joined, I mean, was that note part of your argument or wasn't it? I mean, it may have been a small part, but what was the point of putting it in?
Right. Yes. Yes. It's a note of argument which I'm told was adopted, formally adopted before the court, but I think it's right to say
got lost from sight.
the focus in terms of what was being debated in light of the evidence was the question of real risk or not. Is that fair, David? Yes.
Could we have could it, unless your opponent has any objection, Mr. Bavey, could we have a copy of that?
Yes,
note?
I'll certainly make that available, my lord. Yes, absolutely. Can we arrange for that, David?
You see, Lord Advocate, you've drawn attention to 2 paragraphs in the judgment below, which you say betray the error. And if I've got it right, they're 45 and 58, is that right?
50.
And 50.
58.
50 and 58. Let me just check 50. Yes. Well, in each case, the test is that the question as posed is, would there be a real risk of treatment incompatible with Article 3? What you're asking us to do is to say that, in effect, what they mean is there would be a real risk of harm, which, as you point out, is different
Yes.
from a risk of a breach of Article 3, the one involving the state and the other not. Yes?
That's.
So it may matter how it was put.
I see that, my lord. I mean, if the court reads it in that way, then I do say that looking to the assurances which have been given, those on their face represent reasonable measures of protection.
I understand that.
So that if the court, and my lord is absolutely right, in fairness to the court below, to pick me up on that, and that the court phrases the issue in the way in that way. I say that if that is correct, then the court has plainly erred in not.
Well, you're entitled to say it's an obvious distinction which has to be addressed in every case. But anyway, there we are. That is where we are, is it?
Indeed, my lord. And my lord's absolutely right. And as I say, I would say that standing the assurances and what's said in the assurances, if the court is to be understood in that way, then it is plainly erred, first of all, in not regarding these assurances as providing reasonable protection. And secondly, and I suppose I can put it this way, they don't address the issue in the judgment. Now that may be entirely intelligible given the way that the debate ultimately panned out before the lower court. And if that's so, then so be it. But in my submission, it remains important that the question of reasonable protection is focused.
I mean, it is possible to find in the judgment of Lady Peyton statements which might be taken to be criticisms of the Taiwanese authorities. Look at paragraph 52. Consider it highly doubtful that the prison, even with well-trained and well-motivated staff, has the capacity to be able to provide sufficient protection in the context of the large numbers of prisoners. Then possibly 55, I'm not satisfied there are sufficient medical staff and services available for the prisoners. And then 56, no established UK or international system. Well, perhaps that's not a criticism of the
That's not the point.
authorities. Anyway, I mean, maybe you ought to help us on this point. Perhaps 57, no established route within the Taiwanese courts whereby a prisoner can seek a remedy in respect to prison conditions. Couldn't these be read as criticisms of Taiwanese authorities and the protections they're providing, even with the assurances?
I think the difficulty the difficulty, my lord, is this, and I recognise that these observations are there, is that the way that the court expresses its ultimate conclusion is framed on the assumption that the assurances are fulfilled to the letter.
Yes, but
And that's the way it's put at paragraph 45. So the court, Her Ladyship, observes the only live question is whether the undertakings given in special arrangements proposed, assuming they are fulfilled to the letter, would have the result that the appellant could serve his sentence in Taipei prison without there being a real risk of treatment incompatible with Article 3.
yes, but I think my point was that the assurances don't go to those particular points. The Taiwanese, Lady Peyton might be read as making some criticisms of the Taiwanese system, even with the benefit of full compliance with the insurances. They can't supply a deficiency in medical staff or a lack of access to the courts or
I suppose...
a sufficient capacity, if that's what she's saying, to provide sufficient protection.
At paragraph 43, she says, she introduces all this by saying, it's my opinion that even if it's assumed that every endeavour would be made to fulfil the assurances, there are nevertheless substantial grounds for believing there is a real risk of treatment of the appellant incompatible with Article 3. So one's left wondering, is she saying that she doesn't believe the assurances would be fulfilled? Or is she saying, well, I accept that they would be, but I think there's a risk of breach of Article 3 nonetheless because of the inadequacy of medical care,
Yes.
legal access to the courts, and so forth.
But what's the adequacy of medical attention got to do with protection from assault by other prisoners?
It doesn't, my lord, and there is a
The way
particular
she
point.
deals with it is to compare it with international standards under something called CPT, which she seems to think is the same, or rather failure to comply with it, is the same as establishing a breach of Article 3, which is perhaps something we ought to think about.
Or at least an adminical there. I have made a point in my written case about that, her reliance on medical care relative to the primary evidence, as I understand it. It's not perhaps the most significant, partly for the point, for the reason.
Lord Advocate, I think Lady Peyton's reasoning leading up to paragraph 52, to which Lord Mance referred, can be seen from paragraph 49 onwards, that they could placate resentment if they don't give him a special cell, but that they might expose him to conditions which aren't Article 3 compliant. And then if they do give him the special cell, they create conditions of circumstances of resentment. And she says, but in those circumstances, that they expose him to what she describes as solitary confinement. Yeah. She doesn't seem to be saying that the special cell won't protect him.
No.
Yeah.
But what she seems to be saying is if he does have to stay in his special cell, there'll be solitary confinement.
Yes, indeed, in paragraph 45, she says that the only live question is whether the undertakings and special arrangements, assuming they are fulfilled to the letter, would have a result that there was no real risk of treatment incompatible with Article 3. So she's proceeding on the assumption that the undertakings will be fulfilled.
Yes.
And she seems to be saying that nonetheless she thinks there will be a risk of a violation of Article 3 for the reasons that Lord Hughes has mentioned, and because she's concerned about somebody being not in solitary confinement as it happens, but being confined to his cell for a lengthy period.
Yes. I suppose the difficulty, and it's fair to say, it is a difficulty in the judgment that Lord Dom-Young picks up, is if one is assuming that the assurances will be fulfilled to the letter, then the difficult position, as she puts it in paragraph 49, is really neither here nor there, because one is proceeding on the basis that the assurances will in fact be fulfilled.
Yeah.
The difficult position she describes postulates that the Taiwanese authorities will in fact depart from the assurances.
I mean, the difficulty is, although that she has set out a prospectus at paragraph 49, which assumes compliance with the undertakings, not all of the subsequent analysis is consistent with that, as it seems to me. I mean, just to take one example, paragraph 57, which deals with the complaints process, was the subject of one of the undertakings, but the analysis here is entirely concerned with the general position as regards prisoners in Taiwanese prisons. So I'm not sure that she has in fact done everything that it says on the tin.
Yes, and Lord, as I say, Lord Drummond Young does identify this.
The same point might be made about the comment in paragraph 55 about insufficient medical staff and services. She says, such evidence as the court heard suggested otherwise, see paragraph 33 above. When you look at paragraph 33 on page 130, the foot, as far as one can see, the CPT standard is not met, but the conclusion is, however, there seemed to be no great problem for prisoners obtaining medical attention when needed. I can hardly said that.
Indeed. And one's concerned not here with an individual who has as far as I understand it, has particular medical needs.
Well, your basic point is that it looks as if the word treatment is used in the sense of harm, and so the critical distinction you suggest hasn't been drawn.
Yes.
And we need to analyse these paragraphs in that light, at any rate.
Yes, I think that has to be my position, Lord. And
I mean, we may have to think whether there is nonetheless the material here to suggest that the Taiwanese authorities were still deficient, despite the assurances, in the protections which they ought reasonably to have offered.
Indeed. I mean, my short submission is that if one looks to the assurance, which particularly the one I've referred to, that the steps that are identified in that assurance are, I say, clearly an offer to provide reasonable protection.
Yeah.
The only question then comes to be is, can the assurance be relied upon?
Yes. Well, then, I mean, you have to go a bit further and say there's nothing else in the court's findings on the evidence which really holds water, which suggests that despite the assurances, the Taiwanese authorities were failing in some other area which people hadn't yet got round to asking an assurance for, I suppose.
Yes,
I mean,
yes, I can see that.
As I understand the process, an assurance, as every objection was raised, an assurance was effectively asked for and obtained.
Indeed, indeed.
So it'd be,
and it's perhaps a little tough on the requesting territory to criticise them for responding to issues that are
not responding to issues which hadn't been asked to be made the subject of an assurance.
Well, but also equally, I think there's something maybe in the court's opinion that a series of assurances have been given over time to meet a variety of issues that have been raised.
Yeah.
And in my submission, there's nothing to criticise in that. The requesting territory has responded to concerns about the general conditions of imprisonment with an undertaking to hold the prisoner in a particular cell. They've responded to concerns about safety with the assurance that I particularly found on. And ultimately, if he is not content that they are properly assessing the risk to him and taking steps in accordance with that assurance, he will be allowed to choose to remain in his cell. It's perhaps, I perhaps should just, although I read the majority of the court below as assuming that the assurances will be met. It's perhaps, I perhaps should just say something briefly about that. And first, perhaps I should correct a point in Lord Drummond-Young's analysis, which is this, that the Memorandum of Understanding does not have the status of a treaty, and its terms are therefore not legally binding in international law. That's not determinative, and it's interesting that in Othman, the Othman case, the Strasbourg court was equally concerned with a Memorandum of Understanding, and addressed the point, I suppose, first of all, the UK government position in relation to Memorandum of Understanding was put at paragraph 164, MS 2767, and the court itself addressed the issue at paragraphs 193 and following at MS 2774. And the bottom, I suppose the end point is that the mere fact that the terms of a Memorandum of Understanding or assurances are not legally binding in international law is not determinative. The other point of a similar nature, just for clarification, is Lord Drummond-Young observed that Taiwan has ratified the international covenant. My understanding is that Taiwan is not a party to that convention, but what he means is, or what he must be taken to have meant, is that it's taken steps to implement the covenant within its domestic law. And if I might just shortly say, make my submission as to why it would be correct to proceed on the basis that these assurances can be relied upon. First of all, because of the basic assumption that assurances given in the context of extradition agreements or memorandums of understanding are given in good faith.
Didn't the court below proceed on that basis?
They did.
I mean, do we need to go into it unless it's challenged?
I suppose the only point that I just wish to address, and I can do it in a short, focused way, is the way in which the court below discounted the
right. Yes.
The value of consular protection.
Right.
Now, it may be that this is not, it's a fifth wheel if I'm right so far, but I think it's right that I address that directly. The key documents in relation to that issue are a letter from the Foreign and Commonwealth Office to my predecessor, which the court has at MS 706.
MS?
MS 706.
706, thank you.
In which, in the last paragraph, it's made clear that Foreign and Commonwealth Office staff at the British office in Taiwan are in possession of the assurances. Staff will be aware of those assurances when undertaking consular visits. In the event that Mr. Dean has concerns in relation to observance of an assurance while in custody in Taiwan, he will be able to raise those concerns with British office staff.
So this is Appendix Volume 3, Part 2, page 706 at
Page
the
706.
top, rather than MS 706. Yes.
Not MS.
Oh, I beg my
is
Lord's
it?
pardon, yes. It's I've lost an I can't find an MS number. I
There
don't-
aren't
Is it
MS,
top?
There aren't,
Top.
there aren't MS numbers. I believe.
Oh, isn't it? Well, it's some sort of number at the top anyway.
There's a number.
It would just be the appendix number.
The court has, of course, the assurances, and then at MS 657, which is in volume 2. Sorry, again, it's page 657. I do apologise. And that's a letter from the individual who's given, I think, all the assurances here, Mrs. Chen Wen-Chi, certifying that regarding the prison conditions, if Mr. Dean is extradited, if the consular staff of the British office have any reason to raise an issue about a perceived breach of an assurance raised by Dean, then when the consular staff raise that, the Taiwanese authorities will respond to ensure the alleged breach is remedied.
So what's the position, Lord Advocate? Is it because there are now these assurances and they are given as between the Foreign Office and the requesting territory that a history of consular intervention in prisons generally doesn't give you a guide to what's likely to happen in future?
Exactly, my lord. And my very short point here is that the reason, the key reason why the court below discounted the value of consular involvement was that there are British nationals who are held in Tay Pai in general conditions. Now, because there is because this is the first extradition request from this particular territory, it goes without saying that those are not individuals who have the benefit of assurances. And just to complete the circle, at 654 in Volume 2, there's a statement from the Director General of the Agency of Corrections, who are responsible for prisons, who certify that they will abide by assurances given by Mrs. Chen. So it's a short point. I suppose it arises only if this court considers that it's appropriate or necessary to address whether Taiwan, the requesting territory, will in fact adhere to the assurances that have been given. My Lords, perhaps that's enough on this issue. Can I just very briefly make some observations about what's described as issue 2, which is an issue that the respondent has taken about his eligibility for parole in Taiwan. And it arises because under Taiwanese law, he would become eligible for parole subject to satisfying other criteria once he's served 2/3 of his sentence. He has, in fact, been imprisoned pending this process in Scotland for a period that exceeds that 2/3 period. He's now on bail. That period in prison in Scotland will, in accordance with assurances given, be credited against the total length of his sentence, but is not imprisonment which qualifies for the purposes of parole under the domestic law of the requesting territory. And it follows that he could, applying the domestic law of Taiwan, qualify for parole only once he's served 2/3 of the remainder of his sentence, once credit has already been given for time served. And the respondent also makes a point that if he's compelled to remain in his cell, that will affect his ability to qualify for parole. And he says that because he has, in substance, served his sentence, it would be disproportionate to extradite him. And that's at paragraph 48 of his case.
I mean, effectively, does it boil down to is really getting no credit for the time spent in Scotland?
No, he's getting credit for time in Scotland against the total length of his sentence.
Now, 3 comes off 4. And
Indeed.
it's the balance
Indeed.
which attracts
But-
parole once he's returned.
But time spent in prison outside the Taiwanese system doesn't count under the domestic law of Taiwan in relation to the domestic law of parole. So I think what one could say is that had he not made himself a fugitive from justice and served his sentence in Taiwan, he would by now have passed the 2/3 period and, subject to other conditions being met, would have qualified for parole.
He may, I mean, he's awaiting trial for, or at least he's waiting an extradition request to be extradited, to be tried for absconding, and presumably the loss of parole in respect of this offence might be something that was brought into account in sentencing for that offence, in the sense as a punishment.
Yes.
He might argue that he's already incurring, but that's a different matter.
Yes, I mean, it's fair to say that there's a complicated interaction between the second request and this request.
Yes.
In terms of disposal, if this court were with me, the case would have to go back to the High Court, which left over a Section 108 appeal, which, among other things, is focused on that particular complication.
Yes.
But as the point is put in the respondent's case here, it's focused on this as I understand it, focused very much on this particular issue of the period in prison. I suppose the first point that I might make is that there is a difference between serving a sentence. Parole is, at least as we understand it, parole is not the end of the sentence.
Parole is not?
Not the end of the sentence. Release on license is not.
Well, not here it isn't.
Well, not here, not here. And my short response to this point is the circumstances in which the respondent finds himself as regards eligibility for parole in Taiwan are a reflection, firstly, of the domestic law of parole in Taiwan, and secondly, of the fact that the respondent chose not to serve his sentence in Taiwan,
but fled.
But to flee justice.
This point is before us now, is it?
It's certainly been raised by the respondent in his case.
But to have a case on disproportion, would the respondent have to establish that the prospect of not obtaining parole was an infringement to some extent of his Article 3 right?
Yes, he puts it on under reference to Article 8 and Article 5.
Yes, so he doesn't do it under Article 3. It's in Article 8, Article 5 point, yes, which is otherwise yet to be argued in Scotland. Am I right?
Judgment. My understanding, it was debated in the court below, but it doesn't form yet part of it.
Was argued, yes.
It was argued. It's a bit like the Section 108 appeal, which, as I understand it, was argued before the court below, but the court, in its judgment, has taken the view that, standing the view it's taken on Article 3, that it hasn't been necessary to go on and determine the 108
Is this
case.
what they're referring to? Lady Peyton says, paragraph 61, she says, but it would follow from the decision to allow the appeal in terms of Section 103, but it would not be necessary for this court to issue an opinion in terms of Section 108 or to decide the devolution issue minutes. Are the devolution issue minutes focusing this issue?
I don't understand this.
Mr. Bovey helpfully tells me that there was a devolution minute which focused this point. I'm sorry, I'm not able just to...
So they've heard argument, but they haven't issued a judgment.
Indeed. I mean, one approach might be, I suppose, for the court to focus on issue 1, recognising that the case would then, if I'm correct,
Well, another one, since it's in the parties' cases, would presumably be to deal with it ourselves. I mean, it does sometimes happen that a court below hears argument on a lot of things and only decides the case on one of them. It comes up to us, we decide all of them. If need be, ought we to look at the devolution issue minutes, wherever they may be?
I'm told it's at 622 in Part 2, Volume 2 of the appendix. So that's the, and it focuses, it sets out.
Sorry, where are we? What page?
It's 622 in Volume 2, it's number 28 in Volume 2 of the appendix. And the arguments set out there.
So it's Article 8 and Article 5.
It's Article 8 and Article 5. And the court will be well aware of the injunction in ULA that in relation to questions other than Article 3, successful reliance requires a very strong case. It may be that the right course is to allow Mr. Bovey, if the court is minded to hear this point.
Well, it's in your cases, and it's in the cases before us, and it may not be very convenient to send the case back to start all over again.
Well, there will certainly be, as I say, there's a separate issue of the Article 108 appeal, which focuses on the interaction between the second request and this request. That is not before the court, nor could it be, because the Scottish Government are the primary respondents in that case.
So are you saying this? I'm not sure how long this case has taken already, but it's got to go back again, has it anyway?
It does.
I see.
Yes, regrettably, my lord.
Could I just understand, perhaps you can, if you haven't got a position at the moment, you could address it in your reply, but insofar as the issue of Article 5 and Article 8 is being raised, do you accept that there is, by the absence of parole for the Scottish period of detention, and by the prospect that there may not be parole if in Taiwan the respondent were to have to stay in the cell or not work, would you accept that that is interference with either Article 5 or Article 8? Is that something you've considered? Because we don't get to disproportion, do we, unless there's an interference?
Indeed. And we're thinking about Article 8 in the context of extradition. It's really for the respondent to identify the features of his private life which will be affected by his extradition.
Well, perhaps I can hear you in reply.
I think that might be the best approach, my lords. I say I make these two very short points that the issue arises because of the domestic law of parole in Taiwan. There's nothing on the face of it that so flies in the face of conscientiousness that the domestic law in Taiwan should treat only imprisonment in Taiwan as relevant for the purposes of parole.
You may find useful material on, at any rate, the Article 8 side of things in the decision of this court in Norris.
Indeed,
2.
Indeed, my lord. Norris and HH and BH I'm very familiar with. And secondly, that insofar as the issue arises, it arises because the respondent chose to make himself a fugitive from justice.
Yeah.
So perhaps it's better that I just leave that point where it is, and if necessary, I can pick up any issues in reply.
Right.
Unless I can assist the court further, I'm content to leave my submission there for the moment.
Thank you much indeed, Lord Advocate. Mr. Dixon? Anything you wish to add?
Obliged, I have nothing further to add.
Thank you. Yes, Mr. Bovey.
draw the court's attention to firstly, the issue of competence, and secondly, to the issue of the extent to which the resistance to the appellant's appeal was based upon the argument that we have just heard as the main argument of the Lord Advocate applying the Magdalena-Vicius approach. If I can address the competence, I have summarised my position on competence in the supplementary bundle which was produced today, supplementary volume in ring binders, and at the pages of this supplementary bundle are numbered at the top, and page 1 is the first page at which I have put in my supplementary case. And to cut it short, what I say is that the challenge to the extradition of the respondent was based upon the relevant section of the Extradition Act and failure to comply with the with Article, or an anticipated breach of Article 3, and the respondent did not raise the issue of compatibility with the Scotland Act on the part of the Lord Advocate in resisting his appeal, or the ministers in maintaining the decision to extradite him. And I see that in considering the competence of devolution issues and the appeals, Lord Hope, in the case of BH, which is in tab 4 of the first bundle of authorities, not the additional bundle, at paragraph 24 on page MS 1751, paragraph 24 begins actually at page 1750, dealing with the question of whether the appeal in BH was competent. As has been noted in paragraph 4, there is no appeal to this court from a decision of the High Court Justiciary under section 103 of the 2003 Act. Section 114.13 provides the provision of section 114 to this court from a decision of the High Court do not apply to Scotland. Section 116, read together with 141, provides the decision of the Sheriff of the Scottish Ministers may be questioned in legal proceedings only by means of an appeal in that part. Section 34 makes similar provision in relation to a decision of the Sheriff under Part 1. On the other hand, paragraph 13 of Schedule 6 to the Scotland Act provides a right of appeal to this court against the determination of the devolution issue by a court of 2 or more judges of the High Court of Justiciary with the leave of the court from which the appeal lies or permission from the Supreme Court. This is a right of appeal which is separate and distinct from that provided by the 2003 Act. Now, the issue, as I say, that was focused by the appellant was whether was an attempt to invoke the human rights provision of the Extradition Act. There was no devolution issue lodged in relation to that.
So there's no devolution minute lodged?
I'm sorry?
No devolution minute lodged?
No, there's no devolution minute lodged.
But there was a devolution issue, wasn't there?
Well, no. If there was, well, whether
as defined in the Scotland Act.
There was no devolution issue focused either at any stage. The reason that the minute matters is that the minute requires to be intimated to the Advocate General.
Well, the Act requires also.
Yes.
I mean, the minutes are a matter, of course, of the Scottish Court's internal procedures.
No,
But the Act's a different matter. That's obviously binding on us just as much as it's on them.
The Scotland Act indeed requires intimation to the Advocate General, and it means the rules made under the Act require a minute, but they're secondary legislation. Primary legislation, which we have provided, require that it is intimated to the Advocate General.
Yeah.
Now, that has apparently now been done in relation to these proceedings, and therefore the point falls away in relation to these proceedings, and I accept that. But it hasn't been done and can't now be done in relation to the proceedings that took a number of days before the High Court.
Well, what does that mean?
Well, it means that
They're a nullity or what?
No, because there was no devolution. It means there was no devolution minute and no devolution issue.
Well, no, I mean, those don't follow, do they? Can I ask you a prior question? Did you raise this point at the permission to appeal stage?
I didn't know.
We said, I have a recollection that we considered it. Therefore, I understood that it must have been raised, but I may be wrong.
Your recollection is correct, my Lord, to the extent that the majority of the High Court canvassed it
I see.
and expressed concerns which I have adopted.
They all did.
But I didn't.
Oh, yes, it was in the... Yes, you didn't. Right, well, that was surely the stage at which to raise it, and we did direct our minds to it. Anyway, why do you say you can raise it now at all?
Because it isn't competent for this court to entertain an appeal in the absence of a devolution issue. There was no devolution issue, as demonstrated by the fact that no minute was...
Let's go back to that then. Why is there no devolution issue, bearing in mind the definition in the schedule, which is, amongst other things, a question whether the purported or proposed exercise of a function by a member of the Scottish Executive is or would be within devolved competence, and so on. I mean, here we are concerned, are we not, with a basic question whether this extradition is appropriate, and it's challenged on Article 3 grounds, which seem to raise directly such a question.
Because the issue that was raised by me was in relation to the Section 87 of the Extradition Act, which was human rights, and that's at memory stick 3186.
3186.
In the third volume of the Green Volume.
Yes.
And are not the two inextricably the same?
Yeah.
Well,
I mean, if a judge is required to proceed under this section to decide, he must decide whether the person's extradition would be compatible with the Convention rights. It's the same issue.
Well, in my submission, it isn't, and primary legislation, if the devolution issue had been being raised, primary legislation would have required that was intimated to the...
Well, that's a different point. I mean, maybe that's right. It's now been done. You're not suggesting that makes the whole proceedings invalid, that it wasn't done in time.
Yes,
you are.
I am suggesting that it makes an appeal to this court incompetent. It doesn't affect...
Even now that intimation has been given.
Well, intimation can only be given in relation to the proceedings here. It can't be given in relation to the High Court.
Right. So your case is it that there was never a devolution issue before the High Court, or before the Sheriff's Court?
On this issue, I should indicate to the court. But yes, in relation to prisons, that's my position. I should say there were...
The reason why there isn't one is because there isn't a devolution minute. Is that it?
Because
Or have I got that wrong?
Firstly, because it wasn't focused, and secondly, because it couldn't have been happening because it hadn't. The Advocate General wasn't told about it.
Well, whose obligation was it to tell the Advocate General? You were the appellant to the...
I was the appellant. I pursued my appeal under Section 87 of the Extradition Act and had no obligation to intimate a devolution minute in my submission.
I wonder about that.
The Lord Advocate has powers to intimate a devolution minute if he chooses.
Well, forget about devolution minutes. We're not, speaking for myself at any rate, I'm not interested in devolution minutes because they're nothing to do with us. But devolution issues obviously are.
Yes.
Now, Lord Hope told us in BH that the question whether an act, in that case I think he was focusing on the Scottish ministers, but it could equally be the act of a Lord Advocate, as it's been in some other cases, in extraditing somebody. The question whether that would be compatible with the convention rights is a devolution issue. Because that's the nature of the beast.
Yes.
So it rather looks to me as though both the sheriff and the inner house were dealing with, or the High Court rather, were dealing with a devolution issue. And your point really is that there was no intimation given of it to the Advocate General. So, is that a fair way of putting it? It's a bit like Monsieur Jourdain speaking prose, you know. They may not have realised that's what they were doing, but in reality it's what they were doing.
I think that is correct.
Paragraph 26 of BH.
Can I suggest to your Lordship that the reason that there might be not regarded as a devolution issue is simply because there wasn't one, it hasn't been identified, hasn't been focused up, as to what it is. That what we're talking about is the powers of the devolved administration, and if one can bring a challenge by a side wind, then in my submission that would be quite surprising. Though I see the force obviously in my Lord's analysis as well.
Well,
But would it not be surprising if one was able to use the Extradition Act to mount a challenge to the vires of the Scottish institutions, and this court to be excluded from its review because you chose not to want a devolution minute? That seems to be what your argument amounts to, unless I'm wrong.
I mean, all Section 87 does, on one view, is contain a statutory codification of a particular devolution issue.
Mm. That, in my submission, is not the position. My position is that the issue of what the ministers are doing, what the executive is doing, is a separate issue that requires to be formulated. I'm anxious not to take up more time on this issue, but I should simply, for completeness, draw the court's attention to the fact that in both the Sheriff Court and the High Court, there were 2 devolution minutes raising Article 3. Yeah. And I simply say that so that the court isn't under any misapprehension, but these devolution minutes each issued a different issue from the prison. In the Sheriff Court, the issue was the disproportionality of the sentence to the crime that was complained of, and in the High Court, it was the use of the consent procedure rather than a further extradition request, and the issue of a fair trial. So it was raised, but, and I don't want the court to be under any misapprehension.
Different devolution issues.
Yes, and I can give the court the pages of these devolution minutes in the appendix. They are pages 580, 594, 606 and 613. And again, I'm happy to move on from this issue.
Just before, I mean, I don't want to hold you up on it, but just so I understand your position. As well as arguing that there was no devolution issue focused, as you put it, before the High Court, you also, I think, are saying that in any event, the failure to intimate to the Lord Advocate,
The Advocate General.
I beg your pardon, to the Advocate General,
Yes.
I'm not quite sure what you're saying. Does it invalidate the... You're not saying it invalidates the proceedings in the High Court, do you?
No, the proceedings before the High Court were valid because they took place under the two...
Oh, I see. So rather the failure to intimate to the Advocate General buttresses your... It's really predicated on your being right on your first point.
Yes.
And you're saying, well, if there were a devolution issue raised here, then the failure to intimate would, what, invalidate the procedure that followed?
It would invalidate any, well, it negates any suggestion, or negates the Lord Advocate's suggestion that there has been a devolution minute debated and decided.
All right.
Can I move on to the issue of Magda Novitius? I have to say that the passage that my learned friend has found in a written submission is not in front of me, but I don't doubt that it was amongst the submissions, written submissions made. I can say with reasonable confidence that it was not the focus or structure of the submissions, the oral submissions made, or of the issue that was debated.
I think that's conceded.
And it's conceded in my submission necessarily, bearing in mind that it isn't even focused in the application for permission which was granted in relation to this by this court. So the issue of Magda Novitius comes new to this court, and the criticism of the High Court is against the background of them not having, in terms, been asked to address it. Now, in relation to Article 3, my submission is that the High Court has not erred in its approach, and that the
How long, just a matter of interest, you've got no complaint about the point not being raised now. You've presumably had, although rather inconveniently, it's not dated, the appellant's statement of case for some time.
I have had the statement of case, yes. I'm not taken by surprise in that sense. But my only complaint is on behalf of the High Court, which didn't have the
focus. No, we've got the point.
Yes,
we've got the point.
That is being made. That's the only point I make in relation to that. And in looking at Osman cases, it may be appropriate to look at the recent case of Pantia, which is referred to by the Lord Advocate and is at page 2834 in the European bundle.
And
43.
Indeed, obliged. And the issue of the Pantea case is, in my submission, useful partly because it's a prisoner case, and it is important to remember that Bagdanavicius is not a prisoner case, but a person who had really quite a general fear of racist abuse in the community. And that is quite a different situation. And in the context of the Blog 61 case, I'll be coming to try and flesh out the difference of approach that is required in this context. And we see that Pantea was a former public prosecutor who worked now worked as a lawyer, but who was detained and then put with prisoners who were dangerous. And at paragraph 1, the allegations of mistreatment are at page 2811, essentially that he was put into a prison with a cell captain who was a repeat offender and was beaten up by that person and another person, and then the deputy prison governor simply fastened the applicant to a bed. At paragraph 190, the court reaches its view, or expresses its view. In the opinion of the court, having regard to the nature, and this is page 2834, my lords. In the opinion of the court, having regard to the nature of the right enshrined in Article 3, it is sufficient for an applicant to show that the authorities did not do everything that could reasonably have been expected of them to prevent the occurrence of a definite and immediate risk to his physical integrity, of which they should have known. Knew or should have known. This is a question to be answered having regard to the whole circumstances of the case in question. It is therefore for the court to determine whether in the circumstances of the particular case the authorities should have known that the applicant risked being subjected to ill treatment by his fellow prisoners, and if so, whether they took all measures within their powers, which given reasonable consideration, would have avoided such a risk. So there are four elements there. Firstly, that the authorities knew or ought to have known of a definite and an immediate risk to an identified individual. Secondly, of ill treatment by fellow prisoners. Thirdly, that they failed to do everything within their powers that could reasonably be expected of them.
Is there any statement of principle?
And fourthly, that they would have avoided the risk.
Is there any statement of principle in this case? Does it discuss Bagdanavicius and so on?
quite a good statement of the principle, isn't it?
There is the discussion
Paragraph 190.
of principle, but the approach being taken is the same as in Edwards at paragraph 55 and Osman at 116.
It's all familiar stuff from other cases, isn't it?
It is, and it gives one, in my submission, the content to what was reasonable protection in the circumstances in the Bagdanavicius test. So it isn't contrary to Bagdanavicius. It is simply, because after all, the term reasonable is very broad, and what we see here is how the European Court in practice applies the test. So,
As applied to facts very different from those of this case.
indeed, the facts are.
Does it help?
Sorry?
So how does it help if the facts are not comparable?
Well, the facts are more comparable in the sense that it is a mistreatment by a fellow prisoner.
It's a fellow prisoner case, which Bogdanovicius was not. Bogdanovicius is a straightforward refugee case.
Yes.
Yes, got that. Assuming that 190 is quite a useful distillation
Yes.
of the right approach,
Yes.
are you going to take us to somewhere in the court, in the the High Court's decision, where those questions are confronted?
No, I don't think I can take you particularly to that. I can take you to, and will take you to the elements that are there. As I said in opening, this focus was not put before the High Court, but I certainly will be taking you through the key few passages of the High Court.
We look forward to your doing that at 2 o'clock.
Obliged.